cell phones are turned off and put away, please.
Okay, so good afternoon, everybody, and welcome to the Appellate Division First Department. First of all, you all see from the list that Justice Mansonet Daniels is the JP at on this bench today, and you must be saying, well, my goodness, was Justice Catholic doing the middle? Where's Justice Mansonet Daniels? So she is still the JP, but she is unavailable to sit with us in person today. But she will be viewing the oral arguments on all of the oral arguments today, and she will be participating in the deliberations. So she is, in fact, the JP and a member of the bench. But since she's not physically here, I'll work the clock and call the calendar and do all those things. So that just explains, so you do have a full bench of 5 people here today, even though you only see 4 of us. I'm going to call the calendar. I want to remind you that we have over 5 hours of oral argument time scheduled. We have had an opportunity in the past few weeks to read your briefs and your records. We are familiar with your cases, so please just ask for the time that you really need to make your points. When the white light goes on, that means you still have 2 more minutes. When the red light goes on, that means you should be finishing up your sentence and your time is up. If we have additional questions, we will continue to ask them, but we ask that you abide by the red light. So let me call the calendar at this time. The first case on the calendar is People versus Barksdale. Both counsel, please rise. Let me know how much time you would like. Okay. Okay, 6, 2, and 6. Thank you. Caparita versus Johnson. Okay, that will be submitted. Thank you. Martinez versus Contreras. I guess that will be submitted also. Stevens versus Wheeler. Are you the appellant? Yeah. And okay, I'm going to give you 6 and 2 and 6. If there's additional time, we'll deal with that. Schoen versus Board of Managers. Okay, I'll give you 6, 2, and 6, and let's see how that goes. The next 2 cases we'll be hearing together, People versus Michael Giulio and People versus Harrell. So the attorney for Michael Giulio. Okay, and the other defendant? Okay, and respondent. Okay, so I'm going to give the Michael Julio 8 and 2. I'll give you 10 minutes respondent, and I'll give you 5 and 2. And I think that should work out. If we have additional questions, which we might, we'll keep the time running. Thomas Anthony Holdings versus Goodbody. Okay, and respondent. All right, we'll do 6, 2, and 6. I think that should be enough. If there's a problem, we'll handle it. Triad 11 East versus Midoriya. Good afternoon. You represent whom? It looks like the appellant is not here, so would you like to just submit on the papers, or do you want 2 minutes? Okay, so we'll give you 2 minutes, okay? So no appearance for the appellant and 2 minutes for the respondent. Okay, thank you. People versus Clarence Allen. Okay, respondent? 5, 1, and 5. Okay, thank you. And Duval versus Centerlight Health System, appellant? And there are 2 respondents. You seem to have the same position. So have you discussed how much time you would each one of you want to speak? You each want 5? Well, I'm going to give the appellant 6 and 2, and I'll give each of the respondents 4. I think that should work. Thank you. Atlantis Management, that case is submitted, and Freight Shore versus Board of Directors, that is also submitted. So we will begin with People versus Barksdale.
Hey, Judge, the appellant is here on this tree at 11. I don't know why he didn't give his appearance, but he was here with us.
Okay, so give him 2 minutes. Give him a couple minutes.
Remember something?
Okay, thanks. Good afternoon, you may proceed.
Good afternoon, Your Honors. Brian First from the Center for Appellate Litigation. I represent Mr. Elijah Barksdale. I will be focusing on the missing witness charge issue, and if there's time, move to the weight point. The people here made a strategic decision to not call complainant Wilson to the stand because he was not, in their words, a reliable historian. And
I think also he was not terribly cooperative, was he?
Well, Your Honor, that was the people's position, but if you actually break down what happened here, they say that he was uncooperative from the start, that he was throughout the case uncooperative, but really there was only any effort to speak with him at the very beginning of the case. So to say that he was uncooperative throughout the course of the whole case isn't quite true. And if you look at
Well, they did seem to make efforts to locate him. I mean, they spoke to his brother. He said he didn't know exactly where he was. He didn't have a phone number for him. They served him subpoenas. They went to his home. He didn't respond. So it wasn't like they only spoke to him, I guess, at the hospital for the first time. They did speak to him at other times. Attempt, I should say.
Well, actually, Your Honor, they made no attempt to locate him through his brother. In fact, they asked him, can you locate your brother? He said yes, but they never asked him for help locating him. His brother told him that he sees him.
Didn't his brother indicate that he didn't know where Mr. Wilson lived?
No, he said that he sees Wilson 2 to 3 times per week. He says that he knows that he still lives in the Baruch houses. So I know that people put that in their response brief, but what his testimony actually was is he sees him 2 to 3 times per week, saw him the week of the trial, just a couple days before the trial, and can find him if he needs to. That was his testimony. So this idea that his brother couldn't locate him is totally false. So it really comes down to, I think, this interaction between the police officers and Mr. Wilson at the hospital in terms of his cooperation. And they say, oh, he's totally uncooperative. But if you look at the information, he gave them everything that they needed to apprehend Mr. Barksdale. Based on the information that he gave to them, which was a description of Mr. Barksdale saying a blue hat and a beard, they gave him a general location, his accurate apartment
He
address.
wasn't the only one, am I correct, that identified the defendant. Didn't his then girlfriend also identify him in either a photo or video that she was shown?
Yes, Your Honor, but there's no identity issue here. But I mean, but it was based on, they identified Mr. Barksdale prior to speaking to his ex-girlfriend. They went to see the ex-girlfriend after he was identified in the video by other officers. And the way that they got the video is through the information from Wilson. So this idea that, like the officer said on the stand, he gave them nothing that they could use is not true. He gave them everything that they needed to solve the case, to at least bring Mr. Barksdale in days later. So, again, to the content of what he told them in the hospital, they made a big deal about how this was conflicting stories, the details weren't exact, but if you look at what happened, he had been out all night. He got this gash on his abdomen, and then he duct taped a sock to it and went out and was out of his house for 10 hours before he went and sought medical care. You know, his brother gave him money to go to the hospital. We know he didn't use that money to go to the hospital. And then at the hospital, 10 hours later, they gave him 4 doses of morphine. So this is the state that he's in when the police are talking to him. So he wasn't uncooperative. He gave them what he never said, I'm not speaking to you. he just wasn't a very good witness. He's just an unreliable witness, which is ultimately why they decided they didn't want to call him. So I see I have 2 minutes here. So just briefly, I'd move to timeliness. And the people, I just want to clear up any issue about timeliness. The people in their papers state that this was an untimely request for the missing witness charge. That's not true at all. They say that the judge decided on those grounds. The judge specifically denied to decided on those grounds. Counsel requested the missing witness charge at the pretrial conference, that's page 97 of the pretrial hearings, prior to any testimony being had. So the people were clearly on notice about this. Unless your honors have any other questions about timeliness, I'll move to availability. As to availability, it's the people's burden to prove that the witness, despite their diligent efforts to locate the witness, that they were unavailable. Here we know that the people didn't want Wilson to come in. By their own admission, they didn't want to call him. So if they're not making any efforts to find him, how can those efforts be diligent? Like I said before, they hadn't tried to go through his brother.
Well, I mean, I'm not sure I completely agree with your characterization of that they didn't make any efforts to locate him. You may have made different efforts, but I don't think you could say they didn't make any efforts to locate him. And they did say they went to where they believed was his home. They left a subpoena. They knocked on the door. He never answered. So there was some attempt. He didn't seem to have a phone, or at least they had no indication that he did, so they couldn't reach him that way. I mean, there was certainly a problem. So I don't know if he was, what is the definition of available?
So they have to make, excuse me, I shouldn't have said they made absolutely no efforts. They certainly didn't make diligent efforts. And if you're talking about diligent efforts, they would at least do the most obvious and simple things to try to locate him, which would be to go through his brother, to go to his place of work, which they knew, to go to his neighborhood, to go to the methadone clinic that he visited every single day. You know, they just didn't want to find him. So I see that my time here is up. Unless your honors have additional questions right now, I'll save my time for rebuttal.
We'll save our questions for rebuttal, too. Thank you.
Thank you, Your Honor.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors.
Good afternoon. Now, just to get this out of the way, you did agree with that portion of defendant's brief, which said that this does have to go back, be remanded for resentencing, because he was sentenced virtually without his explicit consent. This was during the pandemic. Am I correct?
Yes, we concede that this needs to be remanded for a resentencing proceeding. Yes. To address the question of the missing witness charge, first of all, I would say in this particular case, it made no difference. The disputed issue at trial, the disputed issue on appeal, was whether the defendant had the intent to cause serious physical injury. There was no issue about whether the defendant attacked Darrell Wilson. There was no issue that he stabbed Darrell Wilson, that he did so with a box cutter. And so this was all on videotape. And
Well, you couldn't really see the box cutter that well on the videotape. I mean, you certainly saw the interaction, you saw the movements, couldn't really see the knife that clearly.
That's true. You couldn't really see that instant when the defendant plunged the box cutter into Wilson's flank. That is true. But the evidence, even without any testimony from Darrell Wilson, was overwhelming that the defendant stabbed Wilson during that attack. It was during that attack that, as the video shows, defendant had an object in his hand, and it was right after the attack that Wilson went home, and his brother saw him bleeding from the side, and then he goes to the hospital, and at the hospital he has what's clearly a stab wound, and there was testimony at the trial that the stab wound was consistent with having been caused by a box cutter, and oh, by the way, 2 days after the incident, when the defendant was arrested, he had a box cutter. So there's no question that the defendant attacked Wilson, that he did so with a box cutter. And so ultimately, Wilson's testimony was really immaterial, or in the parlance of a missing witness
But of course, you know, even if it was immaterial, the missing witness charge coming from the judge who's charging the jury does carry a little bit more weight than, well, I'm sorry, Mr. Wilson isn't here. So, I mean, I think that's what part of the defendant's position is.
Right, but I would say that in the parlance of a missing witness charge decision, the testimony would have been entirely cumulative to the videotape and the other evidence. But in this case, the primary basis that the judge had, I would submit, for denying the missing witness charge was that Wilson was not under the people's control. He was not only uncooperative with the police from the beginning, it's true that he told them, he gave them information that led to their investigation of the stabbing and led to them finding the video of the stabbing, but the only information he gave was, he gave his address and yes, he gave a kind of general description of the person who stabbed him. He didn't name the stabber, he didn't say exactly where it happened. The police canvassed the surveillance video from the vicinity, and they happened to find the video of the incident. So he was uncooperative with the police, and then as the case progressed, and as came out at trial, the defendant called somebody from jail, and he ends up talking to Wilson, and in that phone call, and he tells Wilson to say that this was a photo shoot, that this was a staged incident, and then the defendant produces a purported affidavit written by Wilson saying that it was a, quote, staged incident. And then the only evidence was that of Wilson showing up to court, to any court proceeding, was when he showed up at the defendant's behest. So under that record, Wilson was not under the people's control. He was, by all appearances, under the defendant's control. And so there was no basis for the court to give a missing witness charge under those circumstances. And beyond that, in this particular case, as I have suggested, such a charge couldn't have made any difference. So any error in the court's failure to give the charge was certainly harmless, given the video and all the other evidence, and in light of what the issues were at the trial. And if there are no further questions, I ask the court to remand for resentencing and otherwise affirm. Thank you.
Thank you. Counsel, you have 2 minutes.
Okay, briefly, Your Honor, I don't think that a complainant's testimony could ever be immaterial at a trial, first of all, but here especially, the people, they chose not to call Wilson, and then they specifically argued to the jury that he wasn't there because he was scared to testify, knowing full well that that wasn't true. So at least a missing witness charge would help to negate that, and that's exactly what Savignon says, is that when the purpose of the missing witness charge is to negate any strategic advantage that a party might get.
But counsel, you're not arguing that the laceration was self-inflicted, right?
Was self-inflicted? I'm not arguing that, no, Your Honor.
So,
well,
there also was a surveillance video, right?
There was a surveillance video. Yes, that was the main evidence.
And you're saying that those two pieces of evidence are insufficient to establish guilt?
I'm saying that if we're talking about harm here, if we're talking about whether the evidence was overwhelming, that the people were required to prove, they decided to charge him with attempted first-degree assault, right? If this was just a pure second-degree assault case, it would be a different discussion, but they charged him with
You have a very long wound here. It's 4 to 5 inches long and it's 5 centimeters deep.
Yeah, and the people conceded below that that was not serious physical injury, right? And so the question was, did Mr. Barksdale intend to cause a more serious injury than the one he caused?
Well, the doctor did testify that had it been just a mere bit deeper, it would have gone into the abdominal cavity, which could certainly have led to much more serious injuries and infection to the complainant.
So presumably, if that wound was an inch deeper, then that would constitute, if it said an inch deeper, it would have been in the abdominal cavity, and that could have constituted serious physical injury. Yes, but had he stabbed him with a 6-inch blade, like the case that the people cite, maybe yes, and just got lucky that it didn't go in there. But we're talking about a tiny box cutter that's a quarter of an inch.
Sorry, I don't mean to laugh, but a box cutter is a box cutter is a box cutter.
Well, but a box cutter is a box cutter, but this box cutter's blade was a quarter of an inch from its base to its tip. So for it to have even to get to that threshold of causing serious physical injury, it would have needed to go a depth 4 times the length of the box cutter.
Well,
So
what if he decided to slash him across the neck with the karate
that would
chop?
be a completely different case.
I understand that, but it's a potential to have caused serious. There's case law that suggests that you can have the intent to cause it, even if at the end it wasn't as wide and deep as it turned out to be. That would support a serious injury.
But it doesn't seem like with this blade, given that it had to go a full inch deeper to cause serious physical injury, that it would even have been possible to cause serious physical injury by striking him where he struck him. Right?
Oh, was there expert testimony to that effect?
To what? Yeah, well, that was the medical testimony was that.
But there would have been expert testimony to suggest that that blade was incapable of causing the kind of injury.
No, there wasn't.
We're not discussing had it done what it did. You
Yeah.
said something different, counsel. You raised the notion that this box cutter is incapable
Yeah.
of causing serious physical injury. I take issue with that. And the only way to advance that would have been to have an expert saying, well, with this kind of blade, it would have been physically impossible to do what they think it could have done.
Well, I disagree, Your Honor. I think it's a fair argument under the evidence because the people made a big deal out of the amount of force that Mr. Barksdale used, that he used tremendous force, that he basically like cut him as hard as he could. And if that's the case, and he's still a depth of 4 times the length of the blade away from causing serious physical injury, that's why I'm making that argument that it's possible, it may not have even been possible to cause it. That's the inference I'm making, Your Honor.
Okay, thank you. Thank you both. We'll take another look
Thank
at
you.
these issues. Thank you. The next case for argument is Stevens versus Wheeler. Good afternoon.
Good afternoon, Your Honors. Jeffrey Rosenblum for the plaintiffs and the appellants. Your Honors, I'm here representing a dead man and his estate whose testamentary scheme was so deliberately planned over a period of 10 years with his one and only lawyer, estate lawyer, tax lawyer, business lawyer, and was unjustly abused and disrespected. Mr. Wheeler had represented Mr. Stevens for almost 20 years. Mr. Stevens, the decedent, had followed Mr. Wheeler through his professional career to various law firms where he wound up at
So
this
you
current law
are
firm.
claiming that Mr. Wheeler should have known or knew that he had an office, that your client had an office, or the decedent had an office in New York, and that he had an apartment in New York, and that this was a vacation home in Rhode Island, right?
I'm not claiming it's, ma'am.
That's the fact.
Those are actual facts that Mr. Wheeler would go to Rhode Island to the vacation home. In fact, he was with Mr. Stevens 25 days prior to his death where he reviewed his wills.
So am I correct that the will had no choice of law provision in it?
No conflict of laws provision in it. That was the first case of the negligence, okay?
And also that so the choice was made by the attorney, or the recommendation was made by the attorney that the case should be probated in Rhode Island rather than in New York. And that created, that's the essence of the problem here that you're claiming, isn't it?
It wasn't a recommendation. He ran the estate and in fact prepared, if you look at his time records for that 4-month period, the actual Rhode Island probate forms. And he spent countless hours, I think it was close to 170 hours in 4 months, deciding whether to probate in Rhode Island or probate in New York, and what the tax treatment was in Rhode Island or New York. I mean, these are matters that a competent estate planning lawyer could do in his or her sleep. This is not rocket science.
So once he decided to do that, we know that it changed the result, and and because of that, the parties entered, the wife or the widow entered into a stipulation of settlement with the sons, right?
Actually, it was the daughter, because the wife, being the second wife for Mr. Stevens, had Alzheimer's and dementia. So the daughter, who was not well liked by Mr. Stevens and his children, in fact ran the show in Rhode Island. And once the blunder occurred, I mean, it was a folly that you can take a position that you're practicing in Rhode Island and he's not admitted in Rhode Island. Yes, he's part of an office in Rhode Island that has 3 lawyers that none of them practice a tax or estate law, and he's going to spend $90,000 determining whether to probate in Rhode Island or not. And in fact, in a conversation he had with one of the executors as set forth in the complaint and in the affidavits, he said, why not probate in Rhode Island? There's no change of result. The same result happens in Rhode Island and New York.
Was there
Wrong.
anything else offered?
Pardon me.
Was there anything else offered by way of explanation to indicate that this was part of a legal strategy where there would be something better, something to be gained by probating the will in Rhode Island?
Absolutely not. Mr. Hardy Stevens, one of the sons who was appointed a co-executor, was flabbergasted when he found out from the Rhode Island lawyers who were actually appearing in Rhode Island, Mr. Wheeler did not appear ad hoc fiche, that in fact, excuse me, I have to pay her 50%, the estate 50%, but the deal was a third. Second wife got a third, each of the boys got a third. Well, we're now in Rhode Island court. We can't get out of Rhode Island court. Once you're in Rhode Island court, you can't get out. You can't say you made a mistake. It doesn't work. And at that point in time, and Mr. Wheeler to this day, and his lawyers to this day, and even the lower court has looked at the Rhode Island statutes and said, she doesn't get 50%. She doesn't get anything different than she gets in New York. Now, the law was changed in 2014, and the commentaries in the law review articles are clear and precise. Anyone who reads it comes to the conclusion you get a life estate in your Rhode Island house, and you get 50% of the personalty. And to take the view from the lower court's position that because this was not an intestate estate, therefore the wife does not in fact have a right of election, unfortunately, I believe is what you would call poppycock. It's just terrible because the lower court didn't even understand what a right of election meant, which means that the will is to be set aside, and in fact, you look at the statute, and as of 2014, the statute said she got 50%.
Okay, let's hear from your adversary, and you'll have a few moments to respond. Thank you very much.
Thank you.
Good afternoon, Your Honors. Christopher Scozen of Furman, Kornfeld, and Brennan for the respondents, Alfred Wheeler and the law firm of McElroy Deutsch. The motion court really correctly decided this, our motion.
This was a 3211 motion, correct?
Yes, Your Honor.
So,
case
I
7
mean,
and
how
A1.
could the court decide, I mean, based on what counsel has said and what we have looked at some of the statutes there, how can we just say absolutely that there would not have been any difference when it certainly appears that there was a difference, which also led to this stipulation that the parties ended up entering into to try to move things along? But how could you say that there was no difference, and that this was not the intention, since the intention seemed to be, by reading the papers, 1/3, 1/3, 1/3, not a half?
Right, Your Honor. Well, the complaint sort of speaks that Mrs. Stevens was going to contest the complaint, was going to contest the will, and that's what she did. But she would have done that in New York or Rhode Island, regardless. And it's
Counsel,
pure
but that begs-
speculation to claim
Counsel,
that she.
that begs the question, doesn't it?
Well, I'm sorry, I'm going to address the question, but under Rhode Island law, a spousal election does not automatically get 50% of the estate. Basically, the law in Rhode Island is that if there's no will, or if the decedent dies intestate, the spouse can make an election. She'll get a life estate.
Well, that wasn't what happened here. There was a will.
There was a will.
So-
So therefore, this whole claim that Mrs. Stevens was entitled to 50% of the estate is based on just a theory. And so the motion court correctly decided that the respondents did not breach a duty by deciding to probate the will in Rhode Island, because
So you're saying that the stipulation was entered into unnecessarily?
yes, Your Honor. Well, if you look at the stipulation, it
I
says
mean,
that.
I'm looking at the Rhode Island, I'm calling it the Rhode Island law. But the elective share is called also a forced share, right? Because the surviving spouse can force the estate to provide her with the prescribed statutory minimum despite the testator's contrary wishes. And that's out of a Rhode Island case. I don't know how to pronounce it. People in Ray Gervais?
In Ray Gervais, yes, Your Honor.
Thank you.
But
Okay.
that line in that case is not appropriate to this case. In that case, the surviving spouse received a life estate, and they sought to deprive the spouse of the life estate, but.
But the
that-
widow
that-
here, even though there was a will, did or did not have the option to get 50% of the net proceeds of the estate?
She did not, Your Honor.
She did not.
No, she did not. Not under Rhode Island law. Under Rhode Island law, RIGL 33.1-10 holds that a surviving spouse is only entitled to a life estate and 50% of the surplus not bequeathed. That means that anything outside of the estate. But in this instance, there was a will that covered the entire estate. And so the appellants were probating the will in Rhode Island, and Mrs. Stevens came up with this, apparently she came up with this theory. It's not even really in the settlement agreement. The settlement agreement is to resolve an objection that Mrs. Stevens made to Hardy Stevens' appointment as an executor. But in the settlement agreement, it does say that Mrs. Stevens agrees to resolve this issue with the estate in exchange for a payment by Hardy Stevens and his brother, a portion of their bequest. And in exchange for that, she agrees not to pursue her rights or to pursue litigation.
But isn't, I mean, we've sort of skipped over one of the first questions, is the fact that you decided to bring this case to Rhode Island instead of bringing it to New York, when wasn't the documentary evidence that Mr. Stevens was domiciled in New York? mean,
Well,
that's one of the claims that they make in their
well,
malpractice claim.
sorry, Your Honor. As appellants discussed, Mr. Wheeler met with Mr. Stevens 25 days prior to his death, unfortunately, but Mr. Stevens was in Rhode Island, and they looked at the tax issues and whatnot, the benefits to the estate of probating in Rhode Island versus probating in New York. And they decided to probate in Rhode Island. And there's no advantage that anyone had in.
So what evidence in the record is there that Mr. Stevens agreed with Mr. Wheeler, that they discussed this issue and they planned that they were going to bring the case in Rhode Island? Because it seems to me at first blush that the Rhode Island court was not going to rule sort of in conjunction with with Mr. Stevens' will. It seems like the will said one thing, and the Rhode Island court would end up with a different result. So it's hard to understand that Mr. Stevens would have been agreeing that that made sense if he understood all those ramifications.
Right, Your Honor. Well, the issue that eventually played out with the settlement had nothing to do with Rhode Island law versus New York law.
I don't know how you say that. I mean, I didn't finish the line from Gervais, where it says, despite the testator's contrary wishes clearly expressed in his otherwise binding will. So this doesn't have to do with a person who dies intestate. This deal, that case, that Rhode Island case, dealt with somebody who, where there was a will and where the surviving spouse decided, I'm going to go for the net proceeds instead of the amount, my share of the net proceeds, as opposed to what the decedent decided to leave me.
Right, Your Honor. Well, In re Gervais is not binding on this case, and it's not under Rhode Island law. I'm sorry.
You said that Rhode Island law doesn't recognize this this elective share unless the decedent dies intestate.
Right. There's a certain sort of understanding of the statutes, but there's a purpose behind the survivorship, the election, which is if a decedent dies and he tries to dispossess his spouse in the will, then she can make an election, and that's right and fair. But under Rhode Island law, she's only entitled to a life estate in the property and 1/2 of whatever is outside of the will. Anything not bequeathed under the will. So therefore, Mrs. Stevens, if she didn't like what was in the will, she could have opted for a spousal election, a surviving spousal election under Rhode Island law, and gotten a life estate in the property and whatever was not bequeathed. The will covered everything in Mr. Stevens' estate, so there was really nothing outside of the will.
I'm not sure about that, but I'm going to let, you've given us a lot of food for thought. Let's hear if you have 2 minutes to respond to it. Thank you very much.
Thank you, Your Honors.
I'm not sure I should say anything because, incredible. Just incredible. You have commentary that we produce.
I thought that you certainly argued that there was other things in the estate. There was surplus in the estate.
There was no surplus in the estate. So if I may, because I'm a poodle lover, if I leave my wife $1 in Rhode Island and I leave my $20 million to the Poodle Society of America and I probate my will, there's no surplus. I've just wiped my wife out. Well, the legislature in 2018 in Rhode Island said it only applies to probate because we were very concerned when we changed the statute in 14 to go from life estate in a house to now 50% of personal property, that would cover all types of situations. So we're only going to deal with probate, and we've given you that citation and all the commentary, et cetera, in the law. So the Poodle Society doesn't work any longer. However, any competent lawyer in Rhode Island, and the Andrea Dunbar, who is an estate tax practitioner, Rhode Island, it's part of the record. It is the only Rhode Island lawyer to, in fact, affirm in this action as to it, says you can't do that. But what you could have done, Mr. Stevens, was change your will to call it a revocable trust, re-sign it 5 days before you died, and now your wife is disinherited to the extent you want to disinherit her. But you can't do that under the probate statute. So there's the second element of negligence, and gross negligence, quite honestly, of not practicing properly. And thirdly, the settlement, let's go back. Mr. Stevens was a CEO of, I think, Merrill Lynch, among other things. He has copious notes of every meeting with Mr. Wheeler that goes back 15 years. 20 days before his death, we don't have any notes or whatever that says, oh, by the way, kids, my wife's going to get second wife 50%. Thirdly, if I may, the actual settlement agreement was as to he being a co-executor with a new bank. It had nothing to do with intestacy and probate. Once they were in court, that's where the daughter brings it up and basically strangles them and hangs them. And they make a deal for 50% of that balance. He mitigated his damages. He had to pay her $3 million more. He wound up paying her $1.6 million more, excuse me, the estate did, or the fiduciaries. And that's what we're seeking. Plus, there are probably close
actually, at this point, it's just a 30-11 motion. You're saying it shouldn't have been dismissed on 30-11. You know, you'll get into the merits and all later. This is just a motion.
Yeah, I mean, if I may, I mean,
Well, yeah, you have
under
just,
A1,
you have like 15 seconds, so
okay,
just finish your
okay,
thought.
the documentary evidence that they say, the court says, doesn't utterly refute every allegation. So A1's gone. A7's gone because the law is contra. And the case that you brought up is, in fact, directly on point. It's probably the only case because they went in the life estate scenario prior to 14, and that's where you couldn't have knocked the wife out on the elective share. 1418 now adds a new piece to the elective share. That case is still valid law, and there's no other cases in Rhode Island at
Okay.
all.
Thank you both very much. We'll certainly take another look at this one.
Thank you.
Have a good afternoon. The next case for argument, Shoham versus Board of Managers.
May it please the court.
Good afternoon.
Good afternoon, Your Honors. This is a case about whether or not RPAPL Section 2001 applies to condominium units. And it's a case that, of course, has not been well litigated in this state. The lower court made two erroneous conclusions when it denied our motion to dismiss the counterclaims of the defendant respondent. The first erroneous ruling was that it was unclear if Section 2001 applies to condominiums. There was basically no ruling. The second erroneous ruling was that the plaintiff had failed to establish that the renovation that my client had undertaken was actually a replacement, enlargement, or alteration within subsection 3A of Section 2001.
Counsel, correct me if I'm wrong, but the operative statute of limitation, 2001, is involved with an owner of real property. That's how I read the statute. Do you agree with that?
Agreed.
Okay. And we also agree that the condominium unit itself is the equivalent of a fee, correct?
Real property and a land,
So
yes.
now let's go to the backyard.
Yes.
Which is clear on this record your client doesn't own it as a fee. He has a right to an exclusive use to it as a common limited element.
She is a 3.3% owner of the fee of the common
Yeah,
element.
but well, she's also an owner of all the common units. They have some connection to it, but she's not the fee owner of the backyard.
Correct.
She just has exclusive use. So the real issue is can this statute of limitations be applicable when your client, although she has exclusive use to the backyard, it is still owned by the condominium board of managers in that sense?
By the unit owners, I should say, not the board of managers, it's just an association.
I understand. Then all the unit owners, the point is it's not owned in like her unit, to which there can be a real issue as to whether the statute really applies.
Well, I have two responses to that. One, if we look at the plain language of the statute, it says it applies to land, and it applies in actions to enforce a restrictive covenant. And we have that restrictive covenant in Rule 35 of the bylaws.
So
The second,
I'm sorry, go ahead and finish.
the second portion of that response could be found in the Rahabi case. And if we look at the Rahabi case, which my adversary cites too extensively, and which, by the way, it's not our position that we even need to go down this rabbit hole of whether it's a negative easement or any easement, but the Rahabi case says that we have a situation where there is an easement that both parties are restricted under that easement. If you recall in the Rahabi case, Furman transferred property to Morrison, and Morrison gave back an easement. But when Furman passed away or transferred the property, the second portion of that easement kicked in whereby Rahabi and Morrison were restricted. So it is of no matter who is the owner. All we know is that there's a restrictive covenant, Rule 35, that restricts the use of land, which, as we've all agreed, is the condominium unit and the limited common element.
So I'd like to turn your argument on its head to the extent that the Declaration of Condominium defines common elements as pretty much everything other than the condominium unit. It includes, the definition includes the entire property, including all parts of the buildings and improvements thereon. So I'm troubled by your description of the easement as a restrictive covenant as opposed to an affirmative easement. There is no restriction on her. There's no bar. There's no prohibition. There's an affirmative use that's allowed.
There is that restrictive covenant is, again, Rule 35. And even though you're saying that the land doesn't include these common elements, it does, because even when we look at that declaration, the declaration states that it's a covenant running with the land as well as the common elements.
But the question here is, does she own the area on which the backyard sits? And it doesn't seem that the declaration, the deck, as I always learn to call it, it doesn't seem that the deck recognizes the backyard as, her portion of the backyard is belonging to her.
She's a 3.3% owner of the common elements as defined in the declaration with all the other unit owners. But again, Rahabi makes...
Ergo, if she's a joint owner of the backyard, she's not the owner, right?
She's not the exclusive or full fee owner, but she is an owner. But if we look at Rahabi, it's of no matter who is the owner, because there's three components to 2001. You could have...
And where is there a case, yay or nay, that says that 2001 applies or doesn't apply to condominium?
There is none, and that's the issue, and that's what we're asking your honors to decide in our favor. But my main point is 2001 applies in three scenarios. In an action to enforce a covenant restricting the use of land, which we have that by way of the bylaws and Rule 35. It also applies in an action to recover damages for breach of that covenant, which is what the defendants are trying to do in their counterclaims. And it also applies in an action to recover damages for infringement of an easement. So we have all those three scenarios applying here. So even though we don't have a case exactly on point that applies to condominiums, the clear language of 2001 makes it applicable to condominiums.
Okay, let's hear from your adversary, and you'll have a few moments in rebuttal. Thank you.
Good afternoon, Your Honors.
Good afternoon.
Please the court, I'm William Geller from Braverman Greenspun on behalf of the Board of Managers of the 255 Hudson Condominium. Several of Your Honors' questions really, I think, have captured the essence of this argument. Ms. Schoen's argument is essentially, it's my backyard, I can do anything I want, and anything that restricts me from using that backyard is a restrictive covenant, subject to 2001. What the issue here is that it's not her backyard, it's a limited common element of the condominium, and she can only use the backyard pursuant to the easement in the declaration that says she can use the backyard subject to the declaration, bylaws, and rules. So it limits the ability of her use of the backyard, and those rules very clearly say you can use it, but you can't build anything there.
So the real issue is not so much her using the backyard kitchen or even having a deck there. The issue was that structure that the previous owner put there that Ms. Schoen sort of improved on when she took over the unit.
Correct.
Just that structure. So she could use the backyard, that's unrestricted, but just follow the rules and not have any kind of structures back there.
Exactly, Your Honor. And in fact, the deck that was in there, that's part of the declaration, it says the backyard has a deck, but no structures other than that. So this is not a restrictive covenant. The 2001, the legislative history and the text of the statute makes very clear its purpose is to protect restrictive covenants dealing with property limits, setback lines, sidelines, height restrictions, things like that, where it says if you build your house and it's only 14 feet from the curb rather than 15 feet, technically it's unmarketable, anybody could bring an action. And the Law Revision Commission said that the reason we want to adopt this statute is nobody's ever going to do that, or at least they haven't done it in the first 2 years, they're not going to do that. So that situation is what this is intended for. It is not intended for a condominium where there is this complex web of rights and responsibilities of the unit owners, of the board, and yes, some of the declaration rules say you can limit how the property is used, the rest of them authorize the use of the property. So it is not applicable to here. The other aspect of this is there's a statute, Real Property Law 339J, which specifically gives the condominium board the right to enforce its bylaws and rules. And they can enforce it in a number of ways, including an action for injunction, which is our first cause of action. Second cause of action is for a declaration that this is in violation. And if this is a violation of the rules, the board has the power to impose a fine of $200 a day, every day. That's very clearly in the bylaws.
Counsel,
For each
could you
violation.
address, I'm sorry, could you address the issue of waiver here? Because I found the underlying facts to be curious, at least for me, because the prior owner is the one who constructed the wood and glass panels in lieu of the canvas awning that initially was there, and technically speaking, the prior owner was in violation. And lo and behold comes the plaintiff in 2017. She inherits the situation and then decides to enhance the structure that's there. What say you?
Sure. Well, a couple of things, Your Honor. First of all, when this was described to the prior managing agent, it was described as an awning, which is a projection from a building which has, covers.
We know what an awning is.
Yeah, so, and not an enclosed structure. So it was misdescribed in the beginning.
But you never went to look at it? I guess not.
That's not in the record, Your Honor. But specifically, Article 20 of the Declaration, 203 of the record, and paragraph 12.2 of the bylaws, they have a non-waiver provision. They say that notwithstanding the fact that a prior board, a prior managing agent may not have enforced a particular provision of the bylaws, that's not considered waiver. And when Ms. Schoen purchased the property, it was clear in the filed plans and the filed declaration that this was prohibited. So,
Sir, wasn't there it's in the record, wasn't there the possibility that if Ms. Schoen was ready to pay serious money every month, like $1,500 more a month, bear with me, $1,500 more a month for the life of the 10 years, 100 some odd months, no worries, we can live with the structure, right?
well, the issue here is that there is case law that says a condominium board can license common elements. Most commonly, this happens if somebody has two apartments that are in the end of a common hallway. The board can enter into a revocable license agreement so that for a negotiated payment, the unit owner can pay for use of that space subject to revocation if the board should do that. So we were willing to try and enter into some sort of agreement for that structure to be there revocably for so long as it's convenient for both parties. That's appropriate, but you know, at this point we have sought relief is for removal, and that's the relief at issue here. Thank you.
Counsel?
I'd just like to address the second error that we believe the court made, which was that the alteration was not consistent with Section 3A of the statute. And we asked the court to take a look at the East Island Associates case, which we've cited, which says that all you need to show is that there's an external alteration to a structure. And the respondent even admits that we went from a wood deck to wood paneling, installation of a kitchen, which again changed the outside characteristics of this structure.
What do you do with that non-waiver provision in the agreement?
Well, we're going to basically argue that there has been affirmative consent. It's not even a waiver issue, because how can they argue that my client went in over a course, or sorry, the predecessor went in over the course of a year to construct this in full sight of everyone?
Well, I did sort of ask, you know, you said it wasn't in the record, about how nobody saw that. I mean, imagine would have think somebody could have looked out at their window and seen this, but okay.
Well, you have masonry people, you have contractors coming in with all this equipment. No one asks, where are these people going? Where are they installing here for the past 3-4 months?
So counsel, I mean, I'm looking at the waiver provision in Article 20 of the Declaration, and it really is black and white. No provision contained in this declaration shall be deemed to have been abrogated or waived by reason of any failure to enforce the same, irrespective of the number of violations or breaches which may occur. So are you arguing something similar to, I have an illegal swimming pool in my backyard, and I should be able to keep it because so what, it's been there since forever? I mean, this is a condo situation. There's Department of Buildings requirements, there's certificate of occupancy requirements when you're talking about a structure, and arguably this is a structure.
It is, and that's why Section 2001 applies, and they're arguing that we should set that aside and that the statute of limitations should run forever, that no matter what any statute of limitations...
The operative term that's in dispute is owner, not the type of structure.
I'm sorry?
I think the issue in dispute concerns the definition of owner. You want to expand it to include condo unit owners.
I'm sorry, I don't understand the question.
Not to worry, we're good.
Okay, thank you very much.
Thank you both.
Thank you.
The next cases, the two cases for argument are People versus Julio and People versus Harrell. Counsel for the other defendant, you can sit, there is another defendant, you can sit back there and wait for your co-counsel or the other defense. All right, Good afternoon.
Good afternoon, Your Honors. May it please the court, my name is Claire O'Brien of Selendi Gay Ellsberg, and along with the Legal Aid Society, I am pro bono counsel for the appellant, Mr. Michael Julio. With the court's permission, I will address errors related to the complaining witness and counsel for Mr. Julio's co-defendant in People v. Troy Harrell will address the Batson error. Thank you. Mr. Julio was sentenced to a 10-year mandatory minimum plus 2 additional years following a trial at which the complaining witness appeared, but the defendants never got to cross-examine him. And yet the complainant's hearsay statements were consistently admitted as evidence at trial against the defendants. The first example that I want to address is the hearing from which the court excluded the defendants, where the complainant said 4 separate times that he did not remember the charged incident, that he did not remember the defendants, the people involved in the charged incident, and he also said that he did not want to testify. This was a...
So that suggests nothing that would implicate or be of concern to your client because he had nothing to offer except that he was afraid to want to testify. Parenthetically, was he represented during that hearing?
Yes, Your Honor, he was represented.
Which meant that his able counsel was there to fully question and get to the heart of what Mr. Squire's reluctance or purpose in not wanting to testify.
Excuse me, Your Honor. I thought you were asking if the complaining witness was represented by counsel. He was also represented by counsel.
Okay, but I meant your
Yes,
client.
Your Honor. The defendant's counsel was present, but the defendants also had a right to attend because what the complainant said is directly relevant to the defendants. It had extremely exculpatory power. The people's alleged crime victim said 4 separate times that he did not remember the incident and that he didn't remember the people involved. And identity was a critical issue at trial because, of course, the people had no complaining witness to testify, and they had no eyewitness. And so...
They did have video surveillance in this case.
They had a surveillance videotape, but that tape alone was ambiguous about whether the jury could reasonably infer the elements of each charged crime. And so the complaining witness's testimony that he didn't remember the incident and that he didn't remember the individuals involved in it would have been extremely powerful exculpatory evidence for the defendants to be able to, 1, cross-examine, but 2, introduce live at trial to the finder of fact. And so effectively what the court did in this proceeding was it took evidentiary testimony from the alleged crime victim, and then it introduced that testimony as evidence in trial.
You're saying evidentiary testimony from the complaining witness?
Yes, Your Honor.
But I mean, wasn't it really why that he didn't want to testify, not really evidence about the actual incident?
No, Your Honor. The transcript of the proceeding shows that what the complainant said was 4 times, I don't remember the incident, right. I don't remember the defendants, and what his attorney said was he doesn't want to testify, he is fearful. That information came from the complaining witness's attorney. It did not come from the people's alleged crime victim. What the alleged crime victim said was, that's not the reason. The reason is I don't remember. And
what would the defendants have added to that conversation? Looking solely at the CPL 260.20 issue, in what way could they have participated that would have been meaningful with a victim who's saying, I don't want to testify?
In a couple ways, Your Honor. The first, as I've mentioned, right, identity was a critical issue in this case. And if the people's alleged crime victim had said in open court in front of the judge, I don't remember the people involved, with the defendants sitting right in front of him and their presence didn't jog his memory, that is near dispositive.
Aren't you negating the existence of the surveillance video? It's a long video. And the faces are clear.
But there was no eyewitness to testify that and to point out the defendants at trial and say, that is who did it, right? That is the person on the screen. That was an inference that the prosecutor argued that the jury should make. But if what the defendants got to present to the trier of fact is that the people's alleged crime victim, whom they say is on that videotape being beat up for 3 minutes. The video itself was 6 minutes, but the incident was only 3. If that fact had been presented to the jury that 4 separate times the complaining witness didn't remember the defendants sitting in open court, that's dispositive of the merits or the lack of merit, I should say, of the people's prosecution. But
maybe yes and maybe no, counsel. I mean, it could have been viewed as the victim was, or the complaining witness was hit so hard and so disoriented because of the beating that he took that he just didn't remember. I mean, I don't know where you're going with this, is what I'm saying.
I think that your question highlights the exact issue, which is his testimony, which was taken and presented to the court to the jury as evidence, should have been subject to cross-examination. But, Your Honors, that's not the only example of the complainant's hearsay statements dominating this trial. There are 3 other examples. The first is the complainant's statements to the responding officer that the court erroneously admitted as excited utterances. We know that those were made 10 minutes after the incident. They were made in response to police questioning, and they were made after the complainant had multiple intervening conversations with other individuals.
Was any evidence offered as to the victim's emotional or mental state at the time he made those statements to the officer?
The police officer testified that he appeared disoriented, yes. But the record overwhelmingly shows that the 3 factors that this court should consider in admitting excited utterances, the elapsed time, that was 10 minutes. What happened in that elapsed time? There were multiple other conversations. Who did he make these statements to? Those were police officers, and they were not made spontaneously. They were made in response to a police question. And the fourth overall consideration is, did this individual have a motive to fabricate his statements? Absolutely, because as you can see, he excluded any information that would have implicated his own conduct from that incident.
So you're saying that notwithstanding the fact that Officer Zhang said that Mr. Squire was bleeding from the hand and thigh, breathing heavily, speaking fast, very fast, upset, seemed disoriented, seemed unable to focus very well. You're saying that there was a time lapse long enough that negated all of these, I would say, purported physical manifestations connected to the beating?
Your Honor, the time lapse is just one factor. That is one, and we think it is strong here to rebut a finding of excited utterance. But what is most important is the opportunity for the declarant to reflect. And the video itself shows that the declarant had the time and the opportunity to walk around the store, look for his belongings, interact with other individuals first.
But the jury saw the surveillance video, correct?
Yes.
And so they saw what happened, and they also heard testimony from the officer that he was breathing heavily and seemed that he could have been upset from a difficult incident, and also, you know, you take it for what it is, but the mother also did testify that he was crying and all kinds of upset and anxious and whatever. So weren't these all things that the jury could decide, and they came out this way?
The complaining witness's mother did not testify, Your Honor. That, I believe, is from a different case, People versus Concepcion, which demonstrates that what the complainant said out of court should not have been admitted. But it's the overall consideration of the factors, right? And I think People versus Concave, which we cite, demonstrates that at bottom, what the court should consider is, did this individual have the opportunity to reflect on his statements? And I'll note what the complainant did not say is, I've been stabbed, I need medical attention. What he said was, 3 guys beat me up and took his stuff, and the result was that everyone remained in the store for an hour and looked for his belongings.
Okay, let's hear from the other defendant on the bats and whatever else she would like to deal with, and you'll have time a little bit later. Thank you.
Good morning, Your Honors. May it please the Court, Elizabeth Lagerfeld for Mr. Troy Harrell. I'll be covering the Batson protocol error. The trial court erred in limiting the Batson inquiry to just 2 of the 6 challenge strikes for no discernible reason. The people don't argue that that was proper because it isn't. And this court held the same in People v. Frazier, a virtually identical case involving the same judge and the same error just a few years ago. And here the Batson error is cleanly preserved because the defense counsel objected to all 6 strikes on Batson grounds. It's as simple as that, and that's what the law says you need for preservation on this issue. And that's People v. Davis you can look to for that question. So here we have a cleanly preserved, straightforward error in the Batson protocol. The 6 strikes were raised. The prima facie case, we moved on to step 2. Only 2 strikes got through the entire Batson protocol, and that was simply incorrect. And if it wasn't already obvious enough what counsel was asking for, he even drove home his point after the 6th strike when he said, renewing my Batson challenge, and I'm challenging this strike as well. The court said, I'm not going to address that. And defense counsel said, note my exception. So it was crystal clear here what counsel was asking for. Race-neutral reasons on all 6 challenge strikes. The court didn't give him that. That's clear, straightforward error. And here, the people had an opportunity to contest the prima facie case and to provide race-neutral reasons for all of these errors. They didn't. And so they don't need another bite at the apple for a remand, and actually a new trial is warranted here. At the very least, the bare minimum, remand for a Batson inquiry is required.
I'm sorry, at the very least.
Oh, remand for a Batson hearing is required.
Are there cases, I saw one case where they've done that. They don't usually remand for a Batson hearing. I mean, this is, I guess, about 4 years later. Are there enough notes and things, as far as we can tell, if we were going to consider that?
You know, I can't say whether the people would be able to carry their burden on remand. I would say a new trial is warranted. They already had the opportunity to give these reasons below. It's their position on appeal that they volunteered the reasons for 2 of the jurors. If that's the case, they had the opportunity to volunteer reasons for all of the jurors, and they did not do so. So I think the appropriate remedy here is a new trial.
And there's no harmless error analysis on this issue, is there?
That's correct, Your Honor. It's structural.
Does anyone have any further questions on this? Do you want to address any of the other issues, or are you?
No, if there are no further questions, I will save the rest of my time for rebuttal. Thank you.
Okay. Let's hear from the respondent, and then you'll both have an opportunity to address whatever you would like to.
May it please the Court, my name is Sheila O'Shea, and I represent the respondent on this appeal. I'd like to first speak about the challenges to the round 3 panelists who were Nadom and Rial. And the people rather proffered race-neutral, non-pretextual reasons for striking those panelists, and the judge properly accepted those reasons. With respect to Dome, there were 3 reasons offered by the prosecutor. One was that she wasn't forthright or responsive to the court's questions about what she did for a living. She gave answers such as she delivered certain items or her business performed many services. And I think that people were entitled to want a juror who was a little more forthcoming about her background and about whom the people had more information.
Counsel, fill in a gap for me. Putting aside whether there was the absence of race-neutral reasons for the other 4 among the 6 jurors stricken, was defense counsel given a full and fair opportunity by the court after a race-neutral reason was given by the district attorney's office to be responsive to it, to challenge to it, to address?
Oh, absolutely, certainly. Certainly with respect to, I want to talk about the other 4 jurors in a minute if I may, but certainly with respect to Nadom and Rial. In fact, the prosecutor offered 3 reasons with respect to Rial, which were that she had a good friend in the DA's office, she shook her head yes when the defense attorney suggested maybe someone else had committed the crime, and thirdly, that this particular panelist did not fit the profile of what the people were looking for. Now, only did the defense attorney respond to the first issue, so therefore, the onus was on the defense attorney to say, look, I think reasons number 2 and 3 are pretextual, but he never said that, so presumably he accepted those reasons as non-pretextual. So again, I think there's really no problem with respect to those 2 jurors. We would ask the court to affirm with respect to the Batson ruling for those 2. Now I'd like to discuss the other 4 panelists, if I may. First of all, defendants' challenges are in fact unpreserved. When the people challenged Pena, Martinez, and Jenkins-Cummings, the judge said, let's talk about this round only. Now, there was nothing prohibiting the defense attorney from saying, Your Honor, we are in fact entitled to challenge strikes of jurors from prior rounds. He did not say that. He could have said it at any time during the proceedings. And then a little bit later on, when the defense again opposed to the strike of Furman, the court said, I'm not going to address that. Again, the onus is on the defendant.
But, I mean, we do have interest of justice jurisdiction here on these things.
Yes.
It's a lot of different people. It's 6 different people. There's the 2, there's the 4. So let's say we are looking at it from an interest of justice
Okay,
perspective.
that's fair enough, Your Honor. Well, I would like to distinguish our case from Frazier, if I may. Really, again, for the same preservation reasons. There, the defense attorney specifically asked the court to direct the prosecutor to offer race-neutral, non-pretextual reasons. And I think that's important. Secondly, and this goes to a point I'd like to make in a moment, you're talking about a different group. There was a protected Batson group in Frazier, which was identified by the defense attorney as people of Black, Hispanic, or race-mixed backgrounds. No one questions that that's an acceptable protected group. However, again, I would urge the court not to reach the unpreserved claims, defendant's unpreserved claims in the interest of justice, because the group identified here by the defense attorney was non-white. Non-white has never been accepted by any court as a protected group under Batson. I argue it's too nebulous. I think it's perhaps even akin to the group identified in this court's decision in De Leon, where...
So how many people of color were in the panel, counsel?
Well, that's another problem. There's no record as to that. And again, the burden was on the defendant to make that record. That brings me to
The
my...
6 people that were stricken, the 6 people that are in issue are all people of color. Correct?
We know... There's no record of that. The only mention of anyone's race or ethnicity is that the defense attorney described Furman as a male Hispanic. There's no mention whatsoever of the races or ethnicities. So again, there's a kinship problem here, and I think that the court could simply say that the defense, and the case that I've cited in my brief is Alston.
Well, wasn't that answered by the Court of Appeals in Bridgeforth when they said in cases where the defendant makes a Batson challenge on the basis of color, it is for the trial court using the existing Batson protocol to decide whether the individuals identified as part of that group share a similar skin color.
Right. Similar skin color, I think, is different from non-white. Non-white, there's a question as to what even non-white means. Does it mean South Asians? Does it mean Hispanics? I think it's a nebulous and vaguely defined group, and I think it would not.
Except for the fact that the Bridge Fourth Court also said that skin color is generally an immutable characteristic. So if an inquiry was undertaken, wouldn't it have been resolved rather quickly whether these individuals shared a common skin color and they were being
well, again,
challenged for that reason?
I think that the defense attorney would have had to narrow the group and say, you know, brown-skinned people, you know.
Wouldn't a query by the court have answered all these questions?
But again, the onus is on the defendant to establish a record of the race.
Well, page 333 of voir dire. I'm going to make a defense counsel, Mr. Rankin, I'm going to make a Batson challenge in regards to the people challenging non-white potential jurors. Out of the 3 rounds we have gone through, Your Honor, the people challenged 2 non-white jurors in this round, that being Dome and Riel. In the last round, they challenged potential juror number 16, which was Jennings Cummings. In the first round, they challenged potential juror Pena and David Martinez. And I'm paraphrasing a little bit. And that will be a total of, Your Honor, 5 non-white jurors that were struck by the people, and there have not been any non-white potential jurors that we have seen. The court, let's talk about this round only. Was defense counsel supposed to say, no, Your Honor?
Absolutely.
You're going to talk about what I want to talk about?
Absolutely. If the judge is impatient or curt or even perhaps brusque, that does not relieve the obligation on the defense to preserve its objection. Now, I'd like to get to my 4th point. Again, I just wanted to remind the court that a Ninth Circuit case that I cite in my brief notes that the Supreme Court has never held that a minority or non-white group exists for purposes of Batson. And the judge didn't make a ruling here. So that brings me to my 4th point. If this court feels that the judge did not exercise the proper Batson protocols, the remedy is not a new trial because there's no Batson group here. The only acceptable remedy would be to remand this for hearing, at which point the judge would have the opportunity to make a ruling on the step 1 Batson claim, whether or not there was a prima facie case of discrimination. And secondly, to allow the people to offer race-neutral, non-pretextual reasons for striking those 4 jurors.
You're assuming that all that information is still available at this point in time?
I am assuming that because I've seen some of it in the record. And secondly, even though the 2 assistants who handled the case are no longer with the office, we could call them back to testify at a hearing.
So even though you can't answer our questions, you're sure that you're ascertaining that at a hearing on remand, all of that information would be provided?
I can't give you 100% certainty, but I think someone who participated in the trial for however long it took would certainly have a much better recollection. I have no recollection other than what I've read on the record. But this person may and will likely remember the races or ethnicities of those particular jurors. Perhaps. I don't know is the short answer to your question, but I think that a remand is appropriate to at least allow the people the opportunity, and the judge, more importantly, to make the ruling as to the Batson Step 1 inquiry.
Was Step 1 rendered moot as to any of the 6 jurors?
We concede it's rendered moot with respect to Dome and Riel. However, we do not concede it's rendered moot with respect to the other 4, because the prosecutor only volunteered reasons as to Nadom and Riel, said nothing about the other 4. And in fact, Furman hadn't even been mentioned yet. So there's no reason to think that the mootness issue carried over to the other 4 jurors. So again, I think if nothing else, a remand is appropriate with respect to those 4 jurors only. If the court has no further questions, I'll rely on my brief. Thank you.
Okay, thank you. Counsel, you have 2 minutes on rebuttal.
Thank you, Your Honors. I'll take these 2 minutes to address the additional examples of the complainant's hearsay witness dominating this trial. The second example is the 13-paragraph DD5 report that the prosecutor himself described his eliciting of line-by-line testimony about what that interview with the complaining witness said. The court's ruling that defense counsel opened the door to the entirety of that report was erroneous. Defense counsel asked the detective about what happened at an earlier incident, hours earlier in the day, in a different store. And so by no means did that create a misimpression, but it certainly didn't create a misimpression that the complainant's further statements about what happened hours later in a different store in the charged incident would serve to correct. So that testimony never should have been admitted. And the next example is the hospital records. The prosecutor got up on summation and quoted from a property inventory that was in the discharge papers.
Do you have cases where that has been allowed before to ask questions about that portion of a hospital record?
The prosecutor, the short answer is no. And in fact, Ortega, which is a Court of Appeals case, says, in fact, you cannot do that. But the prosecutor didn't even ask questions about it. What the prosecutor did was submit the records by statute pursuant to the business records exception, and then quoted, and defense counsel objected and asked for redactions to be applied to those records. And the court said, yes, of course. Prosecutor got up on summation and quoted from the inventory and noted that that property inventory did not include a wallet and did not include a phone. Yes, Your Honor.
I'm sorry, but was the defense counsel given an opportunity before the evidence was submitted before summations to redact?
Defense counsel, the court asked whether the DNA records and the medical records could go to the jury. Defense counsel noted for the record before summation that they had not been redacted yet. Said, I expect no issues, but wanted that specifically on the record, perhaps to prevent this type of situation. And so People versus Ortega, which is a Court of Appeals case that says information that's not germane to treatment is not admissible.
But it potentially could be admissible as a separate business record. Now, while it is true that information in a hospital record for diagnosis, not for diagnosis and treatment is generally not admissible. But if the hospital had a protocol of inventorying property of patients, where somebody comes with a clipboard and says, and because they have a bailment issue here, they're responsible, particularly if something gets missing, the hospital could be liable, or there could be insurance purposes for that kind of protocol. Then it would conceivably be an exception to the business record.
I don't think that's allowed under Ortega because the language that the Court of Appeals used in Ortega, which is 15 New York 3rd 610, is that details and records that are not useful for treatment or diagnosis are not considered to be conducted within the routine business of a hospital. And so that would negate its admissibility under both standards.
I'm sorry, I didn't mean to cut you off, but
of course,
one could potentially take judicial notice that inventory records is standard operating procedures with patients in hospitals, particularly when they have to take their clothes off and take their goods and put them in a closet somewhere, and the hospital has to know exactly what you're coming in with because of bailment issues. You don't think that could be part of a routine practice of a hospital outside of diagnosis and treatment?
I don't think that's, Ortega says that it is not considered to be within the regular business practice of a hospital. Because I think the reliability of those records speaks to the need for doctors to diagnose and treat. And so for all of the reasons discussed and in our briefs, we ask that you reverse or at least reduce his sentence. Thank you very much.
Thank you, counsel. Attorney for Mr. Harrell.
Okay, so the people talked about what counsel could have said on the record, but counsel said what he needed to say to preserve this issue, and that's clearly stated in Davis that it's the initial objection to the strike that preserves the request for race-neutral reasons on every strike challenged. So it's preserved. That's straightforward. And even if it hadn't been enough, he did re-object after the last strike. So cleanly preserved here. As the prima facie case, that's no longer at issue here. It's been waived. They didn't challenge that below. And in People v. Payne, the Court of Appeals said, if you don't challenge the prima facie case below, then it's waived and it's no longer at issue.
Counsel, as to Nadom and Riel, what were in your view, the Batson missteps that the trial judge made with respect to those two jurors?
Well, with respect to those two jurors, it was the court improperly ruled that the reasons given were not pretextual. So with respect to Ms. Ndome, we're talking about a demeanor-based reason that's really belied by the record. If you look at the record carefully, she's saying, I work in delivery. I'm self-employed. That it's a straightforward answer. It maybe isn't very specific, but it's certainly not evasive. As to
But
Ms.
under
Rea-
Smokum, they just have to give a facially permissible reason, right? We don't have to be overwhelmed by the reason, it just has to be facially permissible.
To get past step 2, that's correct, Your Honor. But defense counsel carried his burden of showing that it was pretextual despite being a facially neutral reason. And as to Ms. Real, it's a classic sign of pretext when you strike someone who would otherwise be favorable to the prosecution. And this is someone who was friends with an ADA. So that's a classic sign of pretext. And that was the main reason that defense counsel gave below. That thrust of his argument is completely preserved.
So it's that the misstep was made for both Riel and Ndome at step 3.
That's correct, Your Honor.
Okay.
Thank you.
Thank you very much. Okay, thank you all very much. I just want to recognize that the attorney, while everyone, of course, did an excellent job, the attorney for Mr. Julio was appearing pro bono, and we thank you very much for your time and ask you to please thank the firm of Selendi Gay Ellsberg for letting you work on this case. Everybody did a great job, and thank you very much, all of you. Thank you. Okay, the next case for oral argument is Thomas Anthony Holdings versus Goodbody. Good afternoon, you may proceed.
Good afternoon, Your Honors. My name is Eli Rader of Tel Yik. I represent the petitioner appellant. We come to the court because we were denied our routine APL 881.
Well, it's not so routine, counsel. You would agree that the respondent in this record had expert evaluate the validity of Mr. Manowitz and his report, 80-some-odd page report, correct?
That's correct, Your Honor.
And the court, under these circumstances, didn't knock you out of the park, but basically said, I think we need a hearing to flesh out exactly what kind of safety plan you would put forward to adequately protect respondents' property, which the respondent in sworn documentation claimed your client's work actually damaged. Isn't that in the record?
Two things there, Your Honor. One, I would have loved a hearing. In fact, there was a virtual oral argument. There was no record taken. I invited Mr. Manowitz, who participated in that virtual hearing. I held the oral argument. The court had very little questions for Mr. Manowitz. With respect to the damage that was caused, we appreciate that. It is we are told, based on a cursory counterclaim, that there's damage to their basement for approximately $25,000. What we are seeking to do is to remove protections that are at the roof level. The damage is at the basement. In fact, in the seminal case of Rosema, which granted the 881, there was damage in that case, and the court was very clear to say, I'm strictly liable under the statute for any damage we cause. That's why we provide insurance, indemnification. In fact, the damage was an issue when we were negotiating the license agreement, that had we paid enough money, there would have been no issue about removing the protections I'm here today to remove.
Generally, in these RPAPL 881 proceedings, there is an evidentiary hearing with the various experts and witnesses come in?
There can be. This is my specialty. I'd say 8 out of 10 times there isn't. The court hears in fact, the statute itself, read very carefully, says affidavits, if any. The statute is written such that we shall be given access, provided we can demonstrate that it's necessary, which this clearly is.
So, counsel, you want a slam dunk license, right, to work next door?
Oh, Absolutely not. So there's a negotiated license agreement within the record, and we had spent quite a bit of time to negotiate.
But it's not signed, it's not executed, so.
Which is what brought me into court.
Right, so it exists, but it didn't work, right?
It didn't at the end. So there was a time when it was working, and we were going to negotiate this, and we invited them onto our.
So what problems do you have with the hearing?
There was none. There was no hearing. There was just oral argument.
So is that what you're seeking instead?
For this to be heard, I think the court would have seen Mr. Manowitz's site safety plan, which is in the record, which clearly shows the minimal protections we need, which is roof protection.
You have explanations as to explaining the diagrams and all?
Sure, but there are explanations in Mr. Manowitz's affidavit as well as mine about explaining the diagrams, but the diagrams are pretty easy. If we go to page
Well, the judge,
114
the judge indicated that in looking at these documents, she was not able to glean enough information to think that you were entitled to a license, correct? She was.
Well, clearly, right? But what I would like to add is when I reread this decision multiple times before I came up before Your Honors today, I reread the decision multiple times, and as I'm reading it, I'm thinking I'm going to win. It lays out all the roof protection that needs to be installed, that needs to be.
Does it really?
Yeah, the decision itself really goes into detail about the various protections. In fact, it says, as to the roof protection, Manowitz affirms that, as depicted in the site safety plan, petitioner intends to protect the roof of the adjacent property by installing roof protection. He further states that the roof protection will generally consist of 2-inch flame-retardant, rigid insulation covered by 2x10 flame-retardant wood planks, as well as 3/4 flame-retardant plywood on the roof of the adjacent property.
Mr. Manowitz addressed the revised site safety plan or the original site safety plan?
So Mr. Manowitz drafted both. Mr. Manowitz is...
No. In his affidavit, did he address the initial site safety plan or the revised site safety?
I understand the
Site
question, Your Honor.
safety
And it's
plan.
both, because Mr. Manowitz's stone core and shell, which you see as the stamp on the revised site safety plan, it's his entity. Mr. Manowitz is the principal of stone core and shell. So he drafted the revised site safety plan to say to the court on page 114 in site SSP 204, here's the roof protection, and on the record page 119, SSP 601, here's the controlled access zone, and this site safety plan was used to do the exact same work on the other neighbor next door.
So the affidavit was not updated to explain the revised site
The affidavit,
safety.
the affidavit is from the gentleman who drafted the plans the court has before it. So the language in the affidavit lays out what I just said: roof protection, overhead protection, controlled access zone. The plans themselves also depict these protections such that an engineer and architect.
So then the respondent had problems. I mean, they put in papers and they had problems with what they didn't, the respondents acknowledged that you need access to their property, but they had a problem with the way you were planning to protect their property, probably at least in part because they had already suffered damage, at least they alleged they had suffered damage in their property. So as a result of that, Mr. Manowitz and his company provised a revised site safety plan. Was there enough explanation to understand how the revisions responded to the respondent's opposition to the original site safety plan?
Absolutely, except that the site safety plan does not address damages, nor should it. The
Or
site,
roof protection.
So
the
I'm sorry, Your Honor?
The original on which Mr. Manowitz what he addressed in the original site safety plan says no roof protection required.
Roof protection is absolutely required under Chapter 3309 of the Code. The site safety plan that is annexed to the paper.
Does he talk about it?
Yes, Mr. Manowitz's affidavit certainly does talk about it.
So,
Mr. Manowitz's affidavit
counsel, do you see all the issues that are raised?
Sure, but on page
No,
32 of the
what I'm
record,
saying
it talks
to you
about
is,
roof protection.
I'm saying to you that there's so many issues that are raised that seems that a hearing where the opinions of both experts and the experiences of the, and needs of both sides could be heard, fully heard, what might be the best solution?
I wholeheartedly agree that a hearing so that the parties could present their experts, such that they could have a conversation not amongst attorneys, but amongst experts who live with these protections and work through them, I think that would be wonderful, quite candidly. So, thank you.
Okay, thank you. You'll have a minute or two for rebuttal. Counsel, we'll hear from you.
Thank you and good afternoon, Your Honors. My name is Dana Sussman from Kane Kessler, representing the respondents. The first thing I want to indicate is that we had you can call it oral argument, you can call it a hearing, you can call it whatever, I think it's a little bit of parsing at this point, but we had a virtual meeting before the court with counsel. Mr. Manowitz was present on
He didn't
video.
testify.
He spoke, he answered questions. The judge heard him. Mr. Rader.
But let me ask you, if you agree that there needs to be, that they're entitled under some circumstances to access to fix their townhouse next door to yours, how could this be right to just absolutely deny it outright? So you're just going to sit there? I mean, I looked at the pictures. There's all kinds of stuff over there, and something has to be removed. Otherwise, you're never going to have access to those various buildings. So, is it right? Was it correct of the court to just say, okay, denied, rather than say, look, I don't think I have enough information, which I think she said, I don't really think I have enough explanation information to make a determination. Shouldn't have the next step been, okay, now I'll have a hearing where the experts come in and we can work it out?
So to answer that particular question, Your Honor, the standard of review on this appeal is, did the Supreme Court abuse her discretion in denying the license? That's the standard of review, and that's what's before this panel. Based on everything that is in the record, I don't see how anyone can conclude that she abused her discretion. We laid out chapter and verse what was missing from Mr. Rader's application, what was missing from Mr. Manowitz's declaration, what was missing from the voluminous documentation that they submitted that had nothing to do with the protection plans they sought and didn't address anything regarding the license application that they submitted. What they should have done was submit a new application for a license with the proper documentation in order to meet their burden. They didn't do that. They never did it. Instead, they pursued this appeal, and now
they submitted a revised site safety plan.
Well, they submitted a revised site safety plan 1 month after the motion was fully submitted by filing it on the Supreme Court's ECF system under cover of no declaration, no affirmation, no cover letter, and no explanation. They just submitted it. We have looked at that, and this is also in the record, and the court looked at that, even though it wasn't properly submitted, and determined, along with the other documentation that they submitted, that it clarified nothing. It just repeated the same irrelevant plans and drawings that had virtually nothing to do with our building. And if you look at that revised safety plan, and you look at all of the other documentation that they submitted, the 3 areas of protection that they are seeking a license for are overhead protection, roof protection, and chimney protection.
I'm thinking back to having a lot of these hearings once upon a time at 60 Center Street. I mean, if you needed more information, shouldn't there have been something other than the court just saying, okay, denied, go home, and good luck, and the 2 brownstones are sitting there with all this construction material all over it? I mean, something has to be done. I mean, you guys did, you attorneys with your clients did negotiate. I know you never got to a meeting of the minds, otherwise you wouldn't be here. as pretty as it is, but you wouldn't be here. So you knew that that was ultimately what you were going to have to work out. So how does this make sense?
This appeal doesn't make any sense. What would make sense is to affirm the judge's denial of this application because she certainly didn't abuse her discretion. We had been asking for information sufficient to enter into some agreement with these people for a year and a half, during which they flooded the basement, they went up on our roof and trespassed and illicitly extended our chimney flues in a faulty manner, which caused a carbon monoxide and fire hazard, and our people haven't been able to use their fireplaces ever since. Even on this appeal, they haven't submitted enough information or any supplementary information, including a revised site safety plan, in order to determine what it is they want to do.
So, counsel, what you're saying is rather than give your adversary an opportunity to submit all of the missing information at a hearing, your adversary should simply start over and get it right from the beginning?
Well, I think,
I need to ask that question because the issue of the timeline also is very concerning, and any of us who've worked in anything involving construction or renovations or building anything knows that time can be a real enemy in these situations. So what do you have to say about that?
it's a fair question. And I don't think resubmitting an application for an 881 is starting from scratch. It's submitting the information that this part of the case is closed. They didn't meet their burden on this application. Resubmit another one with the appropriate information, or we can talk once they give us the information that we've been asking for years now.
And you're saying that the revised site safety plan didn't fix all the claims or didn't help out?
100% it did not.
Okay. Let's hear from your adversary. Thank you.
On page 24 of the record, you see a photograph of the conditions at the time. And we had built a cocoon structure around our property before we built the addition. The purpose of the cocoon structure, which cost 6 figures to do, was to minimize the impact to the neighbor's property. We did not have to install protections to do so. We lost 6 inches on both sides of our final product because we had to build within the cocoon. Now we have a 1-story addition inside of that cocoon.
Did you drill into a party wall without permission? Is that true?
This is not a party wall condition at all, Your Honor.
I'm asking.
No, we did not. This is not a party wall condition. We built on top of our own independent structure. But we lost 6 inches because we had this plywood that we installed so as to avoid having to inconvenience the neighbor through installing protection.
Is that cocoon still there?
So that cocoon that you see on page 24 is what we have to remove. So we've already been building for about 3 years. This would take about 45 days to finish our project, where this is not a sophisticated development. These are people who are building out of brownstone. It was dilapidated in Chelsea. They are going to live in this home. They did it with the exact same protections under this site safety plan with the other neighbor next door.
So putting aside the allegation that it's really not a family that's moving in and it's a corporation that's flipping the building and all of that stuff, putting all of that aside.
Okay.
When I originally read your side of the equation, I said, let's move expeditiously on this. And then I read their side of the equation, and I said, whoa, there's some safety issues here that are of concern. And your adversary says the best way to do that is make you produce the documentation upfront in a new application, or, as you just heard, provide it to them directly so you can negotiate and talk to each other like you should, like proper neighbors.
So we were successful with our other neighbor. We entered into such a license agreement. We have been unsuccessful here. With respect to safety, we are putting plywood on an unused roof area. That is the extent of the protections.
Whose unused roof?
My neighbors.
So They gave you permission to do that.
No, they have not. That's why I'm
How
here.
come you're putting your stuff on top of theirs?
Because you must, under Chapter 33 of the Building Code, 3309 provides with respect to if you're above somebody's property within 20 feet, you have to put 2-inch flame retardant plywood on the neighbor's roof in case something were to fall. What would fall here is just this plywood that we need to remove. It would take about 45 days for us to remove the plywood, to finish the facade of our building, to remove all the rest of the protections that are below that, and to complete this project. With respect to the corporation, I spoke to Mr. Vincent DiFilippo, who's the owner. I've heard his daughter sing him happy birthday in the background. I've lived with this project for 3 years. This is a brownstone in Chelsea. They will be living in it.
Okay, thank you. We will take a further look. Have a good afternoon.
Thank you, Your Honors.
The next case for argument is People versus Clarence Allen. Oops, wait a second, that's wrong. Triad 11 East versus Midoriya. I think both sides are here now, from what I understand. Sorry. Good afternoon, counsel.
Good afternoon. I'm Ed Miller from She and Associates for the defendant appellant. I'm sorry for not having a jacket. I forgot it in the car.
Okay, when you were racing to get here, which you didn't get here on time, but okay, you had a hard day, so just tell us what we should know about your position.
This is a case concerning the guarantee law. The question is whether or not it applies to this case. I think it does for the following reasons, because there's 3 facts. This was a deli, grocery store, which served food for on-premises consumption.
So,
Go ahead.
who jumps in first?
Go ahead.
So, where? We saw the photographs. They're part of, they're exhibits, and what you have is a grocery store and a deli. There's no tables, there's no counters, there's no chairs, there's nothing where people would be eating or being served food or beverages. If they're taking stuff out of a freezer or a cooler, that's one thing, but that's not what Executive Order 202.3 seeks to encompass, does it?
The pictures do not show the checkout counter, and even though...
We're bound by the record. We can't take your testimony. We can't consider anything that's dehors the record, right?
Well, what you're considering is the pictures which the appellee, plaintiff submitted.
Is there an affidavit that says I have 7 tables with 14 chairs, or I have a long counter with 7 stools or anything like that? Because I didn't see that.
No, there is an affidavit which says, I can read it, Midora Inc. provides food for on-premises consumption.
Right, that's a conclusory statement in my view. It doesn't have any specificity, and given the photographs, there's kind of a problem here.
And the lease and whatever documentation all said for a Japanese grocery and deli. I mean, they didn't, nowhere indicated that there would be a sit-down, and again, the evidence that we have, looking at those pictures, look like it's a very lovely deli, but not in grocery store, and there was a lot of things on sale. We looked down, I looked down lots of different aisles. There were a whole bunch of nice pictures in there, but I didn't see any place where anybody would be able to sit down and eat. I didn't see that your side, unless I missed it, of course, submitted any pictures that would have shown that, other than just this conclusory statement.
I don't hear any question. I mean, it's a fact. That's the only evidence that we have in the record is a statement saying that there is on-food premises food consumption. That's it.
Okay, all right, well, let's hear from the other side, and I've given you a minute for rebuttal. Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Stephen Uden, and I'm with the law offices of Bernard D'Orazio, and we represent the respondent in this case. I mean, Your Honors obviously touched upon the paramount issue, which is that if you look at the record, the proof is very decidedly one-sided to the appellant's detriment. It was their motion to dismiss under 3211, and of course the Court knows the standards on that. And to prove that the guarantee law applies, they submitted this half-sentence conclusion that we serve food for on-premises consumption. No corroborating proof, no corroborating detail. In opposition, not that we needed to because the motion failed on its face, but nonetheless, we submitted a wealth of proof to show that this is a Japanese market. It's a grocery store. We presented all the photographs that Your Honor talked about, their website, which says it's a Japanese market that delivers locally and ships nationwide. There's a sign on the front of the grocery store that says Japanese market. Their liquor license says it's a grocery store that is allowed to sell beer. There's no proof whatsoever that there's any on-premises food consumption. And in reply to our opposition, appellants offered nothing. Not an affidavit, not a single photograph, no proof whatsoever. As I mentioned, they failed in the first instance on their motion, but maybe they had an opportunity on reply. They offered nothing.
So there's nothing on the record that even suggested that they were no longer operating the premises from March of 2020 until they vacated in May of 2021?
No, there's nothing in the record.
So as far as you know, they could have been operating every single day with curbside delivery and everything.
Well, absolutely. I mean, they vacated in 2021, so the presumption is, although there is nothing in the record, that they operated during 2020, in the early days of the pandemic, which would be consistent with their business, which is just takeout and delivery. They weren't affected in any manner by the executive order. So I think the lower court certainly was right. The appellants did not meet their burden of proof, and the lower court's decision should be affirmed. And I just want to add one quick thing. Besides all of this guarantee law has now been determined and declared by the Southern District of New York in the Melendez case, which I provided to the court, to be unconstitutional. And this decision came down on March 31st, just a few weeks ago. So how this impacts the totality of cases in state court dealing with this guarantee law, I guess, remains to be seen. But the federal court has said it's unconstitutional, the guarantee law. And that's persuasive, if not binding authority on this court.
Well, it's not binding, persuasive, I could.
Persuasive, yes. Although it's not material to our case because based on the proof in the record, the law doesn't apply anyway.
Okay.
Thank
Got
you,
it.
Your Honor.
Thank you. Counsel, you have 1 minute to respond.
The record does establish that the company closed on May 4th, 2021, which is within the statutory period, and that was the, quote, event causing the guarantor to become liable. It doesn't mean that the liability had to be instantly applicable. In other words, the liability that was applied.
So the defaults occurred before the COVID-19 period began, right?
Yeah, but
So
the
what you're saying
event
is that there
causing
should
the
be a
guarantor to become liable was
What you're
during
saying
the
is
period.
that part of,
Counsel, let the judge finish.
what you're saying is that part of the debt should be guaranteed by Mr. Hayashi should be canceled or forgiven because of the personal guarantee.
Yes.
Yeah, 22-1005, okay.
Yes, and because the event causing liability was under the lease, the turning in of the keys, vacating the premises and turning in the keys, which he did during the pandemic and because of the pandemic. So that is exactly what that law is there to do.
Okay, thank you. Thank you both. Okay, now People versus Allen.
Good afternoon, Your Honors. Nathan Brown on behalf of Appellant Clarence Allen. This is my first time going so late in the calendar. It feels like a private audience. Mr. Allen is a 70-year-old great-grandfather, 33 years removed from his most recent offense. The court below abused its discretion.
Hasn't he been in prison most of that time?
Yes, Your Honor. That's not particularly relevant to the argument that
Isn't
presented
your
before the court.
concern that by not downgrading from level 3 to 2, he deprived of appropriate housing?
That is one concern, Your Honor.
But it's not a concern anymore, correct?
No, he still lives in a shelter. He's still subjected to the SARA restrictions and has not been able to find housing beyond the homeless shelter.
I thought there was undisputed in the brief. I thought I saw in the briefing that he is in SARA compliant housing now and had.
Yes, the shelter itself is SARA compliant.
Okay. So
I think that's the.
So he's not in the street, and you're concerned that he would have to stay in custody until he get housing is not the case now, correct?
No, now the concern with his housing is that he's not able to live in a supportive environment with his wife because he's still relegated to the shelter system, which is the SARA restrictions, and the level 3 is not appropriate for his particular risk. But addressing the first question as to the years in prison, I think it's important to distinguish the purpose of his sentence versus the purpose of the risk level adjudication hearing, which is what is at issue here. The court failed to consider Mr. Allen's advanced age, which the board itself has stated
Just watch
explicitly.
out what you call advanced age. Counsel? I'd say you should do that. It's not so advanced.
It's the terminology that's used in the guidelines, I'm sorry,
Okay.
Your Honor. So they have stated that the age that Mr. Allen has arrived at is a mitigating circumstance which potentially warrants a downward departure. The court below did not consider this argument.
About the fact that he was incarcerated for 30 years out of his 68 years, and nobody knows who he is or what he's going to become now that he has no superarching correctional restrictions over him.
He certainly does. He's on parole for, at minimum, until he turns nearly 80.
How long has he been out? How long has he been out?
About 2 years.
Okay, so before he went into prison, he raped 3 women who he knew within the course of 12 years. So.
And at the time one of those incidents occurred, he was out on bail for a prior incident. Right. So I don't know how much the parole or the bail is really that effective in his case.
These questions, Your Honors, go directly to the issue that occurred at the hearing, which is that Mr. Allen's age and its effects were conflated with the amount of time that he had spent in prison. And so it's when the board considers somebody's age, it's considered a physical condition, not a situation where they have to form better habits and that time in the community can be used to assess that. It's that, as the research shows, physical things happen to a person as they age. My right knee is in incredible pain right now because I ran a half marathon at 40.
We've had some bad cases, counsel, where people are committing sexual offenses in their quote-unquote advanced years.
The research doesn't say that it doesn't happen. The research says that the likelihood is so drastically low that it represents a reduced risk. And that's all we're saying, that Mr. Allen isn't, we're not asking for Mr. Allen to be off the registry. We're saying that a level 2 is more appropriate for him as he scored on the RAI.
To the extent that SORA aims to protect the public from the danger of recidivism, I mean.
Again,
Yeah.
either way, he's under SORA, level 2, level 3, and I think the added protections of level 3 are not particularly applicable here, where we're talking about somebody who can't live with his wife as a 70-year-old.
Excuse me, is this the same wife he was living with when he committed the last crime?
I appreciate your question, Your Honor, because I wanted to address that before my time was up. I'd like to address a couple things. First, the only argument that my adversary made regarding Mr. Allen's age at the hearing was that it's adequately considered by the guidelines. That's obviously not true because the board doesn't consider it adequately considered by the guidelines. The only other preserved argument is that response to treatment is adequately considered by the guidelines. All of the other arguments made in their brief are unpreserved, and some of them rely on evidence to horse the record, as you mentioned at the last case, that this court cannot consider matters or evidence to horse the record. And the fact that Mr. Allen was living with his wife at the time is a reference made by my adversary to something to horse the record. Even still, Mr. Allen was separated at that time.
Okay, we're going to hear from the respondent, and then you will have a minute to reply. Thank you.
Good afternoon, Your Honors. Elizabeth Schmidt for the people. May it please the court. The SORA court here properly considered defendant's age-based arguments along with all of his other arguments and adjudicated him a risk level 3 sexually violent predicate offender, and it denied properly his request for a downward departure. As Your Honors pointed out, the defendant here has raped 3 different individuals. He has focused his crimes on women that he knows from his own community, and his history shows that he remains a danger to the community because he has committed these acts despite repeated intervention. And as SORA is aimed at protecting the public, the court here did not abuse its discretion in denying his downward departure application and in finding that defendant should be subject to the highest level of scrutiny. Highest level of supervision. Further, his suggested mitigating circumstances don't warrant a departure. His age argument, for example, he provided no evidence specific to him. He only cited studies, which is an argument this court has rejected in the past. His response to treatment was not exceptional. To that point, I'd like to briefly address a few statements that were made in the discharge summary, which my adversary brought up in his reply brief. That document, in addition to the statements we highlighted in our response brief, states that at the time of defendant's discharge from the program, after his so-called breakthrough session, he was rated at only fair at accepting responsibility, fair to poor at his insight into his cycle of sex offenses, and fair at developing a release plan.
What year would that be, if you know?
I believe that was 2018, Your Honor, and if not, then right around then.
Was it superseded by anything saying that he was motivated or highly exceptional or a role model?
It was after that, Your Honor. Those other quotes come from his progress modules, which were completed as he was continuing the program. This is the final statement on his success or lack thereof in the program. I am happy to address our motion if the court would like, but if not, I ask that this court affirm. Thank you.
Okay, thank you. Okay.
Yes, Your Honor. I would just like to address briefly the conflation of time in the community with age. And in addition, the idea that Mr. Allen would be required to submit specific medical evaluations to demonstrate that he is affected by age in the way that nearly every human being is affected. Under Galati, the standard of proof is preponderance of the evidence. And our position is the studies satisfy that standard. To require a specific medical evaluation for every individual would raise that burden of proof beyond what the Court of Appeals has required, and they did so explicitly to protect his constitutional rights to be free from excessive government monitoring and intrusion. Thank you.
Thank you. Thank you both. And the last case for argument today, Duval versus Centerlight.
May it please the court, Matthew Gammons of Rosenbaum and Rosenbaum on behalf of the appellant. There was no neglect to prosecute. There was no
There was no
general
what?
neglect to prosecute. There was no general pattern of delay. At the time that the motions to dismiss were made by the defendants, we were actively and diligently pursuing both the case in Supreme Court, the nursing malpractice case, and also the surrogates court case. The judge, prior to issuing the decision on the motions to dismiss, asked for an update as to what was going on.
Well, I mean, I just want to say to
Yes, Your Honor.
somewhat correct what you said, that there was a fine, the original action was dismissed for neglect to prosecute, which, I mean, you may disagree, but that was why it was dismissed, which is why the prior appeal that was up here in 2020, our court found that you could not avail yourself of that 6-month period in saying. So that, I'm just making a point, although you say there was no neglect to prosecute. In fact, the case was dismissed for neglect to prosecute.
Your Honor, I would argue that that was not said in the motion that Judge Briganti decided. That was later decided by Judge Capella, who said that it seemed as if it had been dismissed for neglect to prosecute. When I challenged that issue and it came before the court previously, I was told that I cannot challenge that because it was not preserved for appeal, because that was not preserved at that point on the underlying motion. So that's the whole purpose of this. I am challenging that fact that that was decided to be a neglect to prosecute. There was nothing about it that was neglect to prosecute. And we have, as I was saying, at the time these motions were made, we were actively and diligently pursuing the letters of administration and also the Supreme Court for prosecuting the nursing malpractice case. At the time the decision was made, there was already, the letters of administration had been generated, granted, and I had already sent a letter to defendants asking them to withdraw their motions and to the court advising the court.
So that was in 2018, or am I wrong?
2018, Your Honor.
So why didn't you let Judge Briganti know before she issued the decision in 2018?
March 14, 2018?
Yeah,
the date of the decision?
By the way, Judge, I know we didn't tell you before the motion was submitted, but motion to re-argue, a motion to renew, we got new information. Look, we find, and I understand that your ability to obtain those letters of administration in the surrogates court is longer than it should be and more trying than you would like it to be. I think we've all seen that in cases we've handled. However, why are we still here 5 years later dealing with the procedural aspect when you had letters of administration appointed 5 years ago?
Very good question, Your Honor. I told the court that. We sent the letter to the court specifically advising Judge Briganti before the decision was issued. In fact, a week before it was uploaded to NYSEF. So we did let the court know before.
And once perhaps it didn't get seen, who knows what happened, wouldn't you, as soon as it come out, said, Judge, motion to renew and re-argue. Well, we just got this information, we sent it to you, you may have overlooked it.
Absolutely, Judge. And the defendants, I talked to them about that, they were intending to oppose that. So the easiest route at that point, when there's been no utterance of the word neglect at that point, no mention of the word neglect, the easiest and quickest opportunity at that point is to refile the motion under CPLR 205A, which is what I did 2 weeks later. There was no delay. If I had imagined waiting for those motions to be decided 6 months, 8 months, doing an appeal on it, that was not necessary because at the time there was no indication this was just.
So I'm looking
yes,
at
Your
the
Honor.
chronology.
Yes, Your Honor.
And the decision by, let's see, Judge Briganti said back in, was it September of 2017, that she was holding the motions in abeyance pending plaintiff's production of proper documentation concerning her efforts to obtain letters of administration in Kings County and proof of the viable delays, blah, blah, blah. Okay, and rather than provide that, there was an affirmation of delay, not opposition. Is that how this all worked?
Yeah, Judge, if you look at the actual.
And then we
I'm
get to
sorry.
March, where you send an e-letter, and the court on the same day says, you're done, but it's entered in April. I mean, this has been, it's like airplanes flying in opposite directions.
A little bit, Judge. As far as that order, that was actually October 30th, 2017, the one you were just referring to. And that's actually the basis of the entire confusion. We all know what happens
But
when
we're in 2023.
Well, I can address the procedural history that brought
Instead
us.
of doing a motion, you did a second action.
So, Judge, we did that, and I can address, you're raising the issue from the October 30th, 2017. That started the confusion. What that said was to give proof of the viable delays in documentary form, an affirmation form, which is what I did. I called it an affirmation of delay because it's asking for me to describe what's going on. It was not an affirmation in opposition. We all know if you ask for adjournment that there's going to either be a briefing schedule or there's going to be an adjourned date from it. This type of order does not result from that. As far as why we're here when this happened then, because after I filed the second action, we had motion practice. They tried to dismiss. At that point, I can't go back to Judge Briganti while I have an active case, active motion pending before Judge Capella. So as soon as that case was decided before Judge Capella, that second action, what did I do? I went directly back to Judge Briganti before the year had even expired. Within the year, as I should have timely done, I went back to Judge Briganti and said, move to restore, move to vacate the old order, because guess what? We have all this stuff, and I should have been able to give reasons beforehand. That was then shuffled over, punted to Judge Capella for no reason. I wrote on the cover of that motion that was done within 1 year to Judge Briganti. That was not given to Judge Briganti. She said, no, give it to Judge Capella. Judge Capella, months later, I think it was 6 months later, it was somewhere in 2019, came back and said, this isn't for me to decide. How can I do this? I can't do this. This must go back to Briganti. So he punts it. So then I go back to Briganti with an order to show cause that sits there for 4 months without even being signed, just waiting for something to happen. Then she writes back, order to show cause declined because Judge Capella's already decided it. When Judge Capella clearly said, I'm not deciding this. I can't decide this. So all of this has been because I can't file multiple motions. Then I had appealed Judge Capella's decision, and it would have been inappropriate for me to file a motion before Judge Briganti when I'm before Judge Capella on the same motion and then before your honors on the appeal.
Okay, so let's hear from
Yes.
the defendant, respondents, and then we'll give you a few minutes to reply.
Thank you, Your Honors.
Your Honors, John Lichtenstein from the law firm Shealy LLP for the respondent Centerlight Health System. Initially, Your Honor, Judge Kapnick, you're absolutely correct. The issue about neglect to prosecute is not before the court. That was before the court 2 years ago, in which you affirmed the decision of Judge Capella. And the motion originally before Judge Briganti was not for lack of prosecution. It was for violation of CPLR 1021, which is merely failing to timely appoint administrator.
And you know, just like he knows, just like I know, that that's not always within the control of the plaintiff's lawyer to get that appointed, but that's what that motion was for.
You could be right, but we do know in the record that he waited until June of 2017 to ask the surrogate court to do it. She had died in 2013. The case had been commenced in 2015. And in the meantime, there had been several orders directing them to do it, in which they were ignoring. So there was absolutely plenty of substantive basis for Judge Briganti to say, yes, you violated 1021. But I'm going to give you a chance to make a motion to restore, which he did not take. What he did was start a new action, and all Judge Capella did was make a very straightforward application of CPLR 205A, which he couldn't do anything other, because you can't argue that what happened before Judge Briganti was not a failure to prosecute. Just can't. So he didn't even have discretion
So counsel, is this the kind of case that calls for us to exercise our equitable powers?
No. What appellant is arguing here, and there's just some subtle points that I'd like to emphasize. One, the motion that was made to dismiss by both respondents came on and was returnable on October 30th of 2017, okay? There was no opposition submitted. So what Judge Briganti did was, I'll hold it in abeyance. That's she didn't adjourn it to December 10th. She said, I'll hold it in abeyance. Now, what does that mean? That means you're not getting an adjournment, okay? But give me what I'm asking for, and then it's going to be submitted. And his entire appeal is built on this claim that they didn't know that it was going to be fully submitted on December 10th, which is absolutely...
Was that date written down somewhere, like control date or something?
Yes, she wrote, it came on to be returnable on October 30th.
Right.
Okay? They were in court because there's a written decision that says, holding it in abeyance, come back on the 10th of December with this proof. Okay? And it was on for an appearance. So there was another appearance. Matthew Gammons had an attorney before Judge Briganti, and he says that he didn't know that it was fully submitted. How did that possibly happen? Obviously, the attorney asked for an adjournment, and it was denied.
Counsel, can I ask you a funny procedural question? In the record, I found after Judge Briganti dismissed the complaint as to all the defendants, that there was a judgment signed dismissing the complaint as to the other defendants. There was no judgment as to your defendants. Did I miss in the record that there was ever a judgment signed relating to your clients? Or do you know the answer to that question?
Your Honor, I do not know the answer to that question. Last thing I just want to raise is that in his very last paragraph of this affirmation of delay, it's in the last paragraph, he asked for an adjournment in order to allow the surrogate to issue the letters. He doesn't ask for an adjournment because there are new facts or other facts that he wants to provide, which is the basis of this appeal. He says, just provide the surrogate court some more time. But the motion had nothing to do with the surrogate's court. Judge Briganti knew that he had submitted the application for the letters in June because the motion came on in September. So obviously, Judge Briganti knew that eventually the letters were going to be issued. The fact that they issued really is not relevant at all. What's relevant was what their actions were up to June when they made the petition, not what happened after.
Okay, let's hear from your co-defendant.
Good afternoon, Your Honors. Sorry, it's empty, so it's so loud now. My name is Jacqueline Mandel. I'm from Kaufman, Borges, and Ryan, and I represent Keyser Nursing and Rehabilitation. With the court's permission, I would like to focus on what the actual application is that's before you right now. So the motion that was at issue was for renewal of the March 14, 2018 order and to vacate that order. And that motion wasn't brought in front of Judge Briganti as a notice of motion until August of 2021, 3.5 years after the fact. The neglect to prosecute is not at issue here. The question before the court is, did the plaintiff satisfy the criteria for a motion to renew? Our position is he did not. And did the plaintiff satisfy the criteria to warrant vacature of an order? And our position is that the plaintiff didn't satisfy those elements either. So what do you need for renewal? You need new facts that did not exist at the time of the original motion that would have changed the prior determination. There are no new facts. I outlined for you in my brief, and I'm sure the court is...
Wasn't the fact that they had been granted the letters of administration a new fact?
It wasn't a new fact because the letters of administration were issued in January of 2018, and the case wasn't dismissed until March of 2018. And so before the dismissal order, this fact existed, and the plaintiff didn't act. So going back.
So even, but I mean, even if, so the judge made the decision, we know that when you e-file things, sometimes that they're up in the universe, things get missed. So when that decision came out from Judge Briganti, and I have to assume that she was not aware that the letters of administration had been granted, plaintiff couldn't have brought by order show cause or some relief motion to renew, re-argue. In fact, the letters of administration were granted, and that's a change of circumstances, something, whatever.
Well, Your Honor, he could have done a number of things and should have done a number of things, because if you go.
That wasn't done. There was no
It
motion
wasn't
made right
done.
away.
He didn't, as Judge Briganti, her decision is extraordinarily detailed concerning the procedure of the case.
Yes.
And there's no question about, the plaintiff is not challenging the accuracy of the procedure as Judge Briganti laid it out. If you go all the way back to the beginning of this, of the facts in the case, the decedent has now been dead for almost 10 years. The plaintiff's attorney, so that was 2013. Plaintiff's counsel was retained in 2014. In 2015, they commenced this action in the name of Geraldine Duval as the duly appointed estate representative for the decedent. And that was a lie, because not only was Geraldine Duval not appointed, they hadn't even started the process. So this whole delay of the 2 years leading up to the ultimate motion to dismiss for failure to substitute is all because they didn't even make an application to the surrogates court until 4 years after the decedent had died in 2017.
When did you're saying they didn't apply till 2017?
Correct, Your Honor, and that is in the record.
Well, wouldn't they have known when they filed the initial Supreme Court action, there's an automatic stay until you get letters? You can't really do anything with it.
You have to.
You have to, in other words, they should have had the letters before they started the action.
Well, that would have been nice, but we get all the time cases that come in with a caption that says, that should have said, if it was being honest. Proposed, Your Honor, exactly.
Right.
And then we would have made a lack of capacity motion, and then 205A would have come into play, but that's not what happened here.
Well, they claim it was a statute of limitations question. That's why they had to do what they did.
They could have, what they should have done was start this caption, Geraldine Duval as proposed administratrix of the estate, and then we all would have known that there had never been a surrogates court proceeding, but instead, they lured us all into believing, because the caption is styled and remains styled now.
In fact, she was the administrator.
That in fact she was. So there's all this is 2 years of going on and on and on. Where are the letters of administration? Hand them over, because we think she's appointed. And how would we know?
So in these years, nothing substantive on this case, like discover, I mean, you probably never even put in an answer, or maybe you.
No, there were answers. There were answers.
Other than answers, did anything else happen in the case?
There was some minuscule paper discovery going back and forth while we were waiting for letters.
So all the volumes on the record on appeal.
I don't even know what that is. I mean, he attached the first appeal that was before this court decided 2.5 years ago as part of the record on appeal. On his renewal motion, he attached every piece of paper, every motion, every court order, everything that has ever transpired. And now I see my red light is on, and I never got to talk about renewal, really, and why there's no new facts, because I sidetracked myself.
We did look at the brief. We do get your point. I don't think you answered our questions, and anyone else have any?
So if I just may briefly
15
conclude by
seconds.
saying that there were no new facts. Everything was already known and in the exclusive possession of the plaintiff's knowledge at the time of the dismissal order, and that is why renewal was inappropriate. And then as far as vacature is concerned, because the motion to vacate was not brought until 3.5 years later, the plaintiff had to give an excuse.
Okay, I think those are kind of basic. Thank you for the other background.
Thank you,
Okay,
Your Honor.
thank you, Ms. Mandel.
Discovery was complete except for depositions of the parties. Everything had been given. My response to combined demands had been given. Bill of particulars had been given. Authorizations had been given. Medical records had been given. The medical records for both institutions had been given. That's why the record on appeal is so large, because everything had been given. The only thing that's missing from that is transcripts. In fact...
And the letters.
And the letters, Judge, thank you. Everyone knew there was no letters. Everyone knew. That was why this got adjourned the way it did. We would go to court. I'd say, working on the letters, this is what's happening. Let me update you. It was wide open. Neither of these attorneys were present. I was present. And when I was present, this is what occurred every time, and I put this in my papers. It was adjourned for the purpose of me getting the letters of administration issued. Now they're trying to act like they didn't know.
You didn't commence that, you didn't commence the surrogates court action until 2017?
No, Your Honor. We had, in fact, we started to file the petition for letters of administration when we were advised by the family that they believed there to be a simple will. They lived in another state. They looked for this simple will. They found the simple will. It was not delivered to us until November of 2016. So the answer is yes, Your Honor, but there was a lot of reasons which are in my brief for why we waited this long to be able to get to this point. And before that, let me just address this. Until you even know there's a meritorious case, there's no point in appointing administrators. So every case, when you get it, you get the medical records, you have your experts review it, you look through it, you decide if it's a meritorious case, then you go to appointed administrator. I would not have asked the clients to put up, to go through that process if we had not had a meritorious case.
Okay. All right. Well, thank you. We'll take.
Thank you, Your Honors.
Thank you very much.
Court is now recessed.